The English law, inequality of bargaining power. The doctrine of inequality of bargaining power in English law is with controversy, which shall examine the case Lloyds Bank versus Bundy. Mr. Bundy, an elderly man not well versed in business affairs, gave his bank a guarantee regarding his son's business debts and mortgaged his house to the bank as security for the guarantee. In entering into this transaction, Mr. Bundy relied implicitly on his bank manager as his advisor, but the bank manager was also acting on behalf of the son, thereby creating a conflict. But the bank manager was also acting on behalf of the son, thereby creating a conflict of interest. When the bank sought to enforce the guarantee against Mr. O. Bundy and obtain possession of the house, Mr. Bundy defended the action on the ground that the mortgage had been improperly obtained. The majority of the court decided the case on orthodox grounds, holding that the bank had failed to rebut the presumption of undue influence because they could not show that Mr. Bundy had been independently advised. So this principle of the inequality of bargaining power sort of was set out by Lord Denning in his general principle, in the general principle of inequality of bargaining power. English law gives relief to no one who, without independent advice, enters into a contract upon terms which are very unfair or transfers property for a consideration which is grossly inadequate. When his bargaining power is grievously impaired by reason of his own needs and desires, or by his own ignorance or infirmity, coupled with undue influence or pressures brought to bear on him by or far for the benefit of the other. Lord Denning's principle of inequality of bargaining power and questioned whether there was any need for such a doctrine, given that Parliament in statute such as the Consumer Credit Act 1974 has undertaken the task of placing such restriction upon freedom of contract as are necessary to protect the most likely victims of inequality of bargaining power. Lord Scarman has a different view from that of Lord Denning. In Pao Ong versus Lau Ying Long, 1980, Lord Scarman, giving the judgment of the Privy Council, said that the agreements were not avoidable simply because they had not been procured by an unfair use of a dominant bargaining position. Lord Scarman, giving the judgment of the House of Lords in National Westminster Bank versus Morgan, Lord Scarman specifically disapproved of Lord Denning's principle of inequality of bargaining power and questioned whether there was any need for such a doctrine. However, although Lord Denning's principle of inequality of bargaining power has been rejected, it should not be assumed that the courts will stand by and allow the strong to push the weak to the wall. In other words, the court will not allow the strong to bully the weak. Okay. This is clearly understood that the court will not allow the strong, the big boys, to bully the smaller boys. It can be seen in Alec Lop's Garages versus Total All Limited. Even in National Westminster Bank versus Morgan, Lord Scarman recognized the existence of an equitable jurisdiction to grant relief against an unconscionable, so we talk about conscience, being unconscionable or unfair bargain. Lord Scarman refused to confine the jurisdiction of equity within rigid limits, saying that the court in the exercise of the equitable jurisdiction is a court of conscience. Thus, we find that equity intervenes to relief against unconscionable bargains. Earl of Chesterfield versus Jansen. To set aside an agreement made with an expectant heir. The Earl of Alresford versus Morris. To set aside an improvident bargain made with a poor and ignorant person, Creswell versus Porter. The jurisdiction is set aside an improvident bargain made with a poor and an ignorant person has been stated to be in good heart and capable of adaptation to different transactions entered into in changing circumstances. Example, Credit Loynes Bank, Netherlands versus Barge. And examples can still be found of contracts set aside by the courts on the ground that they constitute unconscionable bargains. For example, Bonstani versus Bigot, 1995. Now, there are two principal objections to this development. The first is that the failure of the courts to define the basis of their jurisdiction leads to uncertainty and inconsistency. So that's the first failure. The first principle is the failure of the courts to define the basis of their jurisdiction leads to uncertainty and inconsistency. Is the basis of the doctrines the inequality between the parties, the unfair nature of the terms, the knowing taking advantage of the weakness of another, or some combination of these factors? It would appear that the answer is that the courts look for a combination of factors. So the combination which was required by Blair in Storydom was a Ramsay. One party have been disadvantaged in some relevant way as regards to the other party. That the other party must have exploited that disadvantage in some morally culpable manner, and resulting the transaction must be overreaching and oppressive. The advantage of this approach is flexibility. The disadvantage is that it can generate uncertainty. It is flexible, but it can generate uncertainty. An example of uncertain state of the current law is provided by Bonstani versus Bigot, where the precise reason for the lease being set aside does not emerge from the advice of the Privy Council with any clarity. For example, is provided by the case of Portman Building Society versus Dunson, where the Court of Appeal distinguished the decision in Barge, and in doing so appeared to place greater emphasis on the need to show morally reprehensible conduct on the part of the defendant before a claimant can set aside a transaction. The insistence on the need for some positive advantage taking by some more powerful party, the big boys to bully the smaller boys, has been the subject of some criticism on the ground that it fails to encompass the case in which the terms of the contract are substantially unfair, and the claimant was to the knowledge of the defendant vulnerable, but the defendant was a mere passive recipient of the benefit. A restrictive doctrine of unconscionability permits a defendant to benefit from the non-vulnerability of the claimant, provided that the defendant does not take active steps to procure the benefit in a manner which can be characterized as morally reprehensible. On the other hand, to the extent the scope of the doctrine to include the case of a passive recipient may generate even more uncertainty. Now, we've thought about first principle. The second objection is that although there is no general principle of inequality of bargaining power, it remains to be seen how far these residual equitable doctrines will be resurrected to play the role which Lord Denning envisaged would be played by his doctrine of inequality of bargaining power. Section 140A of the Consumer Credit Act 1974 gives to the court the power to make an order. If it determines that the relationship between the creditor and the debtor arising out of the agreement is unfair to the debtor because one of the following, or more of the following: A. Any of the terms of the agreement or any related agreement. Now, looking back to this, let's try to analyze the thing again. It determines that the relationship between the creditor and the debtor arising out of the agreement is unfair to the debtor because one of the following. It's unfair, right? Any of the terms of the agreement or any related agreement. In other words, the agreement was drafted either in a way you call it contra preferendum or lopsided agreement, which is treating the whole issue unfair to the debtor. The other way is which the creditor exercise or enforce any of his rights under agreement or any related agreement. The third one is any other thing done or not done by or on behalf of the creditor, either before or after the making of the agreement or any related agreement. The following can be seen in Plevin versus Paragon Personal Finance Limited. Third, the alleged unfairness must arise from one of the three categories of the costs listed in subparagraph A, B, and C. Finally, although the great majority of the relationships between commercial lenders and private borrowers are probably characterized by large differences of financial knowledge and expertise, and so are inherently unequal, it cannot have been Parliament's intention that the generality of such a relationship should be liable to be reopened for that reason alone. Lord Sumption noted that Section 140A, 140A is deliberately framed in wide terms. First, what must be unfair is the relationship between the debtor and the creditor. So, relationship between the debtor and the creditor. Second, that although the court is concerned with hardship to the debtor, matters related to the creditor or the debtor may be relevant to the court's inquiry. Next, Section 140B confers broad powers on a court in order to remedy the unfairness in the relationship between these parties. Thus, they can, for example, order repayment of sums paid, reduce or discharge any sum payable by the debtor, or alter the terms of the agreement. Now, consumers have also been given rights of redress against traders in respect of certain forms of unfair commercial practices, including misleading and aggressive actions, which could encompass actions which amount to duress at law or undue influence in equity. The rights given to the consumer include the rights to unbind the contract, the right to a discount, rights to damages. These rights are additional to the rights available to a consumer at common law or in equity, but may not be exercised in combination with those rights. It's the end of this subtopic, inequality of bargaining power. The next topic in YouTube we're going to study it's about unconscionability. We're going to look at an unconscionability. What is the meaning of unconscionability? That's the next topic. Thank you for now.